Ladies and gentlemen, to Illinois Law, brought to you as a public service by the Illinois State Bar Association. This evening we begin a discussion on adult guardianship, which will be aired in two parts. In the first part tonight, we will answer the question, do I need an adult guardian for someone close? And next week's program will be entitled, So You've Decided to Seek an Adult Guardianship, What Next? I'm Judge Cheryl Cesario, and I currently sit in a guardianship court in Cook County. This evening, I'm here with three prominent attorneys: Nancy Spain from Spain, and Varnett, Greg Garofalo from the Garofalo Law Group, and Meg Benson, the Executive Director of the Chicago Volunteer Legal Services. Nancy, I'd like to start with you and answer a very basic question. What is a guardianship?
Guardianship is a legal proceeding where a person with a disability is adjudicated, which means the judge finds that the person has that disability. And a guardian, a person is appointed to help them make decisions for money or for their personal matters.
Meg, who can be a guardian?
A guardian can be anyone who's over the age of 18, who's a resident of Illinois, who has never been convicted of a felony, and is of sound mind. That's what the law says, but more importantly, a guardian should be someone who knows the potential disabled adult, who cares about him. It's usually a family member or maybe a really close friend. And in rare instances, sometimes when the disabled adult has no one in his or her life, it can be a state or county agency.
Now, Greg, why would an adult actually need a guardian appointed on their behalf?
Well, somebody would need a guardian if they're disabled either physically or mentally. Now, I say disabled and not mentally ill. A disability would be something like for a physical disability, they can't take care of themselves and they need somebody to help care for them. A mental disability, which is what we see most of the time, is a disability such as a type of dementia that could be vascular or of the Alzheimer's type. Maybe somebody who suffered a traumatic brain injury due to an accident, or even a young person who was born with some sort of disability and just can't care for themselves and make their own decisions.
So is it fair to say that someone might need a guardian at any time in their adulthood?
That's fair to say, absolutely.
Well, how does the court decide, Nancy, if a person needs a guardian and who that person should actually be?
Well, it's something where there's a doctor's report, and I think that the courts look very carefully at the report that a physician, and it has to be by a doctor who has examined the person and determined that they are totally incapable of making decisions. And it can be incapable of making a decision about their person, about whether they are able to take care of themselves and make sure they eat and make sure they don't do things that are bad for their person. But there's also a guardianship of the estate, and if they're incapable of making financial decisions, then they need someone who can handle their finances.
Like, what standards, though, would a judge use to decide whether or not it's in a person's or a person actually needs a guardian?
Well, as Nancy said, they're going to look at the physician's report, and the physician is going to say that this person is incapable of making personal or financial decisions. The court will also then look and make a determination as to what is in that person's best interest. Does this person need a guardian full-time, not part-time, but limited? We'll talk, I think, more about that later, but some people may need a guardianship for their financial decisions, but not for their person. They can go to school, they can go to work, they can go out, but they need a guardian to help them with some decisions. There's a lot of standards, and the judge is going to look at what the doctor says. They'll talk to either the disabled person or a guardian ad litem, someone who's appointed to talk to them, and get all this information and make a decision.
Greg, does the disabled person actually have to appear in open court?
They don't have to appear in open court, but it is one of their rights. They have a right to be present in court. But the court does take into consideration whether or not it's in their best interest, whether it's safe for them to appear in court. But just because they don't appear in court does not mean that they give up any rights.
And how would they then be informed of their rights if they don't appear in court? How would they know? In fact, how would they even know that somebody was seeking a guardianship on their behalf?
Well, when somebody files a petition for guardianship over an alleged disabled person, the court automatically appoints something called a guardian ad litem. And the guardian ad litem is the eyes and the ears of the court. And the guardian ad litem is charged by the judge to go out to visit with this alleged disabled person and inform them of the proceedings, inform them of their rights. There's certain rights that they have pursuant to the Probate Act. So they would tell this individual what their rights are, and then they would ask them, how do you feel about the guardianship? They would explain the guardianship and find out what their opinion is. Then they report back to the court.
Now, can more than one person be a guardian for an individual, Nancy?
Yes, actually, a guardian, there can be co-guardians. Generally, the courts want to make sure that if there are co-guardians, that they're of the same mind, that they have the best interest of the ward in mind, and get along and see things the same way. Obviously, if the two guardians don't get along, it would make it difficult to proceed with being co-guardians.
Well, Meg, what if a brother and sister don't agree on what should happen with their mom? In other words, one wants their mom perhaps to be in a nursing home because they think that's how they'd be cared for best, and the other sibling thinks that mom's best suited to stay in her home, maybe with some help in the house, or maybe even with that person. What happens in a case like that?
Ultimately, that's the judge's job to decide what is going to be done with their mom. The court will listen to both parties if they have lawyers, and hopefully they do, because it really is something that people need lawyers to come to court with them to explain and to argue, talk for them. But the judge is going to listen to them, and they'll say what they believe is best and why. They can bring other witnesses. They probably will have a doctor or a specialist, maybe a social worker or someone who knows their mom, knows what the story is, who will testify, and the judge and the guardian ad litem will be there, and the guardian ad litem will make a report. The guardian ad litem, the eyes and ears of the court, will have talked to other experts and talked to mom and seen how mom's living and gotten an idea of what mom can and cannot do. All this information comes to the judge and presented in court in a hearing under fairly formal circumstances where everyone gets to present his or her case in their best light. Then the judge makes the decision.
Now, we've sort of alluded to the fact that we have personal decisions made on behalf of someone who can't make them for themselves, and monetary decisions. Is there actually a distinction within the guardianship itself, Greg?
There is. I know that Meg's talked a little bit about the personal guardianship. With regards to the financial part of the guardianship, that's called a guardian of the estate. And that guardian is charged with managing the money of the disabled person. It's the disabled person's money and not the guardian's money. So the guardian is accountable to the court because the court oversees the money and makes sure that it's protected for the disabled person. That guardian would have to account to the court, tell the court of all the money that's received by the disabled person, how the money is spent, and come into court and set up a budget for this disabled person so the court knows how the money is being spent on an annual basis.
All right. So what would you say then if I asked you what the duties of a guardian of the estate are in particular?
The duties of guardian of the estate are to gather all the assets, protect the assets, and make sure that the money, like I said, is spent the proper way according to the court's direction, and then to account to the court on how that money was spent.
And so what kind of assets might we be talking about here?
Well, there could be anything that someone owns. The court would be responsible, the guardian would be responsible to the court, and the court would want to know about any of the assets. It could be a home and cars, it could be stocks or bonds. It could be property in another state. It could be anything that a ward owned.
All right. And in terms of being a guardian of a person, Meg, what kind of a decision might a guardian of a person face?
The guardian of the person will decide, they may be deciding what that person does for the day. A younger person who has developmental disabilities might be going to school, might go to a training program, a sheltered workshop. The guardian's going to make those decisions. The guardian's ultimate responsibilities is to make sure that their ward is properly clothed, properly fed, educated if necessary, has something to do. They're not going to let them just lay around, sit in bed and watch TV unless that's really in their best interest, which is often not. They make decisions, they take them to the doctor. They get their health checked. They can't agree to anything invasive. They can't approve surgery without going back to court and getting the judge's permission, but they take them for dentist appointments. They take them for checkups. They make sure their physical health is good, that their mental health is good.
And just like Greg talked about an accounting, which I think is due annually to the court, what about a report if you only have guardianship of the person? Do you have a report like that too?
You do. An annual report. It's a very simple one-page form that the court gives you, and you submit that. You file that with the court every year. It doesn't cost anything to file, and you can mail it in. And it asks you, it just verifies where the ward is living, and it asks, I haven't seen it for a while, but I think it's just a couple of paragraphs. What do they do and how are they doing, basically. Very simple.
And what about placement, Nancy? What if a guardian of a person decides that maybe mom's living in the home or dad's living in the home and he needs more care? What is done in that kind of a situation?
Well, the guardian cannot move a ward to a new residence without court approval. The court wants to make sure that the residence is an appropriate place, a safe place. So there has to be a petition to the court asking for permission to move to a different residence. If a child is at home, particularly, and the child would then be moved to a residence that's not within the home, that would be something the courts would really want to make sure that it's an appropriate placement.
All right. And then in terms of the court proceeding itself, does the judge actually want to see the guardian or the proposed guardian, which we call the petitioner, in open court? Must you come to court?
Yes, I think the judges really want to see and make sure that they have a conversation with the guardian, make sure the guardian exudes interest in the ward and is an appropriate person.
And what about a guardian of the estate? Greg, what would the judge be looking for there in terms of a person? Do they have to come to court too? Absolutely.
The judges want to be able to charge the guardian with what their duties are going to be and the responsibilities. I think the judges want to be able to have a comfort level that these individuals understand what they're undertaking, because it is, as one judge has put, a very awesome responsibility.
All right. Thank you very much. We're going to take a short break now for a special announcement, and when we come back we're going to continue our discussion. We're going to touch a little bit on powers of attorney.
Bye, Tyler.
Bye-bye, Tyler.
Dear, it's time for serious talk.
Oh?
About my daycare. When I started out, it was just to help the neighbors. But lately, it's getting to be a real handful. I need some help.
What can I do?
I need advice on more space, a loan,
What about incorporating?
and insurance.
Wait, I know who we can call.
Times like this require sound advice. Your lawyer can help. A message from the Illinois State Bar Association.
It's your fault!
Over and over.
Leave me alone! Shut up! Out!
Time and again.
No! Drive me nuts! Shut up! You're the dumbest
Generation after generation.
I hate you! I hate you too!
Isn't it time we stop the cycle? Now.
I hate you! I hate you!
Stop adult violence. Teach kids peace. A message from the Illinois State Bar Association.
Welcome back to this edition of Illinois Law, where we're discussing adult guardianships. When we left off, we were talking about the duties and responsibilities of a guardian of the person or estate, or person and estate, of an individual over the age of 18. We'd like to turn our attention now to the difference between a guardianship and a power of attorney. This is something we hear quite a lot about, and there can be a lot of confusion about. Nancy, what is a power of attorney?
Power of attorney is an agreement by a person to have someone who's called her agent handle things for them. There's a power of attorney for health care, and there's a power of attorney for property, and it's where the principal, the person who's giving the ability to act for them to their agent, asks or signs a paper that allows the agent to do specific duties for them. And it can be very specific or limited, or it can be quite broad.
Now, what about this particular form, this power of attorney form? Does it have to include certain things? What does the law say about the form itself, Greg?
Well, it's pretty broad. There's many different kinds of powers of attorney, but I think the most common powers of attorney that we see are called short form statutory forms, and they're taken right out of the Illinois Statute Power of Attorney Act. And there's a power of attorney for property and a power of attorney for health care. And there are specific powers within those, each one of those powers of attorney given to the agent.
Hey, when you fill out a power of attorney for health care, and you're making the power and giving it when a certain time period comes up, what are you asked in that power of attorney for health care to decide?
It can depend on what the person who is giving you the power of attorney has specified, and it could be something as simple as agreeing to providing medical assistance, and it could become something much more serious than that. It varies on what the person has asked you to decide.
Well, does the person who's giving the power of attorney, does that person's in the power of attorney for health care say anything about end-of-life decisions, for instance, Nancy?
They could. It's recommended, we always recommend that the person making the principal give direction to the agent so that there is some understanding as to what the principal would have wanted if he was able to make the decisions. Generally, it comes into use when the person is not capable, for whatever reason, of making a decision.
Now, what about a power of attorney for property? What kind of powers are actually allowed in that circumstance?
There's several powers of attorney. As I mentioned, the short form power of attorney includes things such as managing bank accounts, managing investments, access to safety deposit boxes, filing tax returns, instituting lawsuits on behalf of the individual if they can't do it themselves. Pretty much any kind of financial decision that an individual would make if they could make it on their own, the agent would be able to make it for them.
Now, do you need a power of attorney if your parent is getting a little bit older and it's become difficult for them to either remember to write checks or just to pay their bills or simply some kind of a chore? Do you have to necessarily have a power of attorney to manage or help your parent, your older parent, manage their checking account to pay regular bills? Nancy?
It could be helpful. The question would be whether or not the parent at the time, if the child is coming in to have the parent prepare a power of attorney, it's important for the attorney to know whether or not the parent is in a position to make that decision, to enter into a contract, to have a power of attorney. If the parent has problems with dementia or the inability to make an appropriate decision, then the power of attorney won't be valid.
Well, when is the right time for an individual to actually execute or make a power of attorney? Is it when they've, reached an age in their older years, or should we be thinking about some planning in this area? Meg?
We should be doing it now, all of us. Everyone should have a power of attorney. Not to say that I do necessarily, but we all should. And you do it when you are young and healthy, and then every few years you look at it and make sure it is still what you want and it's still current.
And what about the child who, and of course the child we're talking about is some adult, probably 40 or 50 or 60 years old themselves, but how about if they sense that it would be helpful to them to help their parent to have a power of attorney? If your mom or your dad has, or your sister or your brother, an older sister or brother perhaps, has moderate or severe dementia, is that a time to seek a power of attorney?
By then it's too late. If they have dementia and it's severe, if it's really, really early stages, it may be okay, because for most part that person is capable of making decisions and communicating those decisions. But after it gets to a certain stage, you cannot do a power of attorney. That person has to be of sound mind and able to know what they want and communicate that. So it's probably too late. At that point, if you need to make decisions for that parent, that's when you may need to go get a guardianship.
Well then, what about a will? Does the same hold true for a will, Greg? Should we not encourage our parents without wills who have moderate or severe dementia to make a will at that time?
Well, I think, as Meg said, it really depends on how far this dementia or this possible mental disability has gotten. I think that, again, as Meg has said, now is the time when our parents are healthy or our family members are healthy is when they should be doing it. As it gets into that area in which there may be some question, it might not be a good idea, because then you're just inviting a fight amongst the family over whether or not mom or dad had the capacity to execute the will, and then you're going to end up in a family fight.
Indeed. Nancy, what would you say the average age of a single or a married couple is that comes in to have you do estate planning for them?
That's an interesting question. I would say the average age is anywhere from late 20s to 70 or 80.
All right, so there are some people that are
Planning
cognizant
ahead
of this and do take the steps early on to put, because one of the points we always say, I know in court to people is, if you let people know what you want, then hopefully the court will be able to bolster and enhance what your wishes are, when you are not at a point that you're able to do that for yourself. Meg, I think we talked a little bit about having a mentally ill relative, and that's probably not something that where guardianship is appropriate. Do you want to comment on that for me, though?
Guardianship is probably not appropriate when the relative or the person you're taking care of is mentally ill. Guardianship gives you responsibilities. You have to make sure that person is properly clothed, fed, cared for. And a mentally ill person may not listen to you, may not do what you want them to do, and you don't have the rights. You can't do what you may want to do. You cannot force that person to get treatment. You can't force them into residential care. You can't make them take their medication. You don't have those rights, and a guardianship doesn't give you those rights, and the judge in a guardianship case can't make that happen either. So there are other ways to get a person mental health treatment. You can petition the mental health court and for some help, which you may or may not get. But a guardianship isn't going to give it to you, and yet you're responsible for reporting to the court annually on how that person's doing.
Now, the court, you mentioned mental health court, just to be clear, adult guardianships are generally, in most jurisdictions, In what division, Nancy?
In the probate division.
In the probate division, where we also then handle the decedent's estates, and those are deal with some wills and trusts and things like that. I just want to touch briefly before we end today on the issue of elder abuse. Where are cases of elder abuse, either physical, emotional, or financial, and neglect? Where are those cases heard? Briefly, Greg.
Those cases, well, right now they are heard in the probate division. However, in Cook County, there is a new elder adult division that is being started. It hasn't quite started taking cases yet, but so right now you would look to the probate division.
All right. I'd like to thank all my guests this evening, Nancy Spain, Greg Garofalo, and Meg Benson. As we began our discussion on adult guardianship, please join us next week when we talk about the actual bringing of a guardianship petition and what you need to do for that. Thank you very much. Welcome, ladies and gentlemen, to Illinois Law, brought to you by the Illinois State Bar Association. This evening we continue our discussion on adult guardianship, which has been aired in two parts. In the first part last week, we answered the question, do I need an adult guardianship for someone close? This week's program is entitled, So You Decided to Seek an Adult Guardianship, What Next? I'm Judge Cheryl Cesario, and I currently sit in a guardianship court in Cook County. With me tonight are my guests, three prominent attorneys, Nancy Spain of Spain, and Varnett, Greg Garofalo of Garofalo Law Group, and Meg Benson, the Executive Director of the Chicago Volunteer Legal Services. Greg, just to recap, can you tell the ladies and gentlemen of our listening audience what a guardian is?
A guardian is an individual that's appointed by the court to make personal and financial decisions for a disabled person, somebody who has some physical or mental disabilities and can't make decisions for themselves. That could be a full guardianship, making all decisions, or it could be a limited guardian, making just some decisions, or sometimes on an emergency basis, it could be a temporary guardian charged with certain powers to make certain decisions.
Nancy, what are the types of guardianship?
Well, there's guardian of the person and guardian of the estate.
Now, what does the guardian of the person focus on?
The guardian of the person focuses on basically everything except the estate, everything but the financial. So it's where the person lives, going to the doctor, making decisions on day programs, and what is best for the person for their day-to-day living. Guardian of the estate is the person who takes care of the person's finances, maybe pays the bills, invests the money, takes care of their finances.
And what if a person has a building that they own with renters, or a business that they own? What happens in situations like that?
My suggestion would be to have a guardian who is a professional, maybe a corporate guardian. But if the guardian is an individual, the guardian would have to take responsibility for that 2 flat, collect the rent, make sure the insurance is paid, the mortgage is paid, so that they step into the shoes of the ward and have to handle all the financial things.
When you say a corporate guardian, who generally functions as a corporate guardian?
Well, there are banks that do it. There are also some corporations that are just handle guardianships and and they're not individuals.
What about the case of someone who really has nobody to act for them? Say you have no children, your husband or wife is deceased, or you were never married, you have no nephews, no nieces, and there's just no contacts that anyone can find for you. What happens in a case like that, Meg? Who can become a guardian of the person if someone still needs decisions to be made?
There are government agencies, state and county. In Cook County, If the person has needs a person only, there's no money or an estate up to, I believe it's $50,000. The Office of State Guardian becomes their guardian. That's a state agency. If they have $50,000 or more in an estate, then it will be the Public Guardian's Office, which is run by the county.
I think it's $25,000 or more, isn't it?
It's 25,000.
Yeah.
Oh, I'm sorry. It went down.
That's
That's
okay.
so
I just don't want to
I'm so sorry.
give misinformation.
No, you're right.
All right, what's the very first thing to do if you wish to bring a petition then for guardianship before a court? What's the first thing to do, Nancy?
Well, the first thing we would recommend, and I don't mean this self-servingly, but it would be to hire an attorney. I think that there are a lot of legal questions that have to be answered and procedural things that need to be done. And although it's possible for a family to do that for themselves, to get a guardian for their disabled child, for example, but there are a lot of things that need to be done in a certain order, and it's just better to get an attorney. And if you go in interviewing attorneys, it's very important to make sure that the attorney you do hire is someone who has been in the probate division, does handle guardianships, and is aware of all the rules.
That's a good point. Actually, the probate laws are what we call statutory, and they're very specific, are they not?
Correct.
Now, what happens if you don't have any money, Meg, to hire a lawyer?
There are
though?
some legal aid agencies in Chicago and Cook County that will help you. They generally are person only, because if there's an estate, if there's money, there is enough money to hire a lawyer. The lawyer can be paid from the estate usually. If it's person only, Chicago Volunteer Legal Services, the agency I work with, we do guardianships. Center for Elder and Disability Law, Chicago Legal Clinic. Those are the three that do the most of them. There's might be some other ones.
Well, let me ask you this. What if you don't qualify for even those legal service agencies? Is there any help for individuals who want to try to do this on their own if it's a guardianship of the person only?
Yes, there is a help desk over at the Daily Center, 1202. They're open when the courts are open, 8:30 in the morning until 4:30, Monday through Friday. They will take anyone, and it doesn't matter what your income is, person only, and you can't have it can't be a contested matter, or no one can object. You're going to be filing to have somebody, probably you appointed guardian over someone. If you know someone in your family is going to come in and fight it, they won't do it.
They won't help you out.
They will not help. But if it's a straightforward, no contest, they will do all the paperwork for you and walk you through the process. It can take anywhere from 90 minutes to 3 hours, because they're going to take you all around the courthouse. It's a fairly complex procedure. You've got to file a lot of paper, and you have to go up to the courtroom and get a court date, and then take that and send notice. It's a procedure, and they will spend all the time you need with you that day. They don't charge anything.
Who is that staffed by? Is there lawyers sitting there?
It is staffed by staff attorneys from Center for Elder and Disability Law, and they are helped by law students. It won't cost you any money for their services. If you are low income, below a certain level, the court costs will be waived by the court. However, if you're, and that's a very low level, if you make over that income guidelines, you will have to pay your own court costs.
All right. And there is a significant cost to filing a guardianship petition, Greg. What is that cost?
I believe the cost is just under $300.
With the service and the filing costs.
And then I was going to say, there's also, the individual has to be served by the sheriff. So the cost is probably anywhere from $300 to $500.
Now, Nancy, if you have to open a guardianship of the estate because the alleged disabled person has significant assets, do you have to have a lawyer then?
Absolutely.
Why is that?
If the guardian of over an estate needs to have a bond, a surety bond, and if it's not a corporate guardian, and in that case there has to be a lawyer on the matter, or the surety bond will not be able to be written.
Greg, what's a surety bond?
Surety bond is it's insurance, essentially, and it's insurance that the guardian is going to manage the money and spend the money according to what the court directs. If for whatever reason the guardian misappropriates the money or misinvests the money and does something they're not supposed to pursuant to the court's direction, then this insurance company would come in and make the disabled person whole.
Nancy, how does the court determine what the bond should be?
The bond has to be 1.5 times the value of the liquid assets, not just liquid, but not real estate. Real estate's not included in that calculation.
Now, is everybody required to have some kind of a bond, Meg?
Yeah, if there's no estate, you have a no surety bond.
There's no monies that the person has.
You have a no surety bond, which means you're not putting up any money, but it's still your word. You are promising to do the job that you are signing on for, to take care of this person, to make sure that they're okay, and to report back to the court.
All right, now you mentioned, Meg, that it's a lengthy process and you can be at the courthouse trying to do this for about 3 hours on any given day, sometimes less though. But what about this issue of notice? What do we mean by notice and why is it so important, Nancy?
Well, there are two different kinds of notice. One is notice in terms of service of process. There are, when a guardianship is opened and a guardianship is established, we are taking rights away from the person, and in that sense, their due process right is to be given notice and be given an opportunity to fight the guardianship if that's
the alleged
inappropriate.
disabled person you're talking about.
The alleged disabled person has
All
that.
right.
And notice generally, however, would be to all other family members who may have an interest, may have knowledge of the case. They have a right to be heard as well, because there might be a reason why they believe there shouldn't be a guardian, or maybe the person who's petitioning is not the appropriate person to be the guardian. So family members need to be given notice as well.
So anybody we give notice to in a case, do they have a right to come to court then and be heard?
They have a right to come to court.
And be heard?
And be heard.
Now, I'd like to just touch again on this issue of when a court might appoint a guardian ad litem. For instance, if the alleged disabled person is able to appear in court, generally, does the court appoint a guardian ad litem in that case, Nancy? Meg? Look at it, Meg.
It depends. It depends. In so a lot of the cases that we're involved in, it is an adult child who's living with his or her parents and has always lived there and is going to continue to live there. If that adult child can come to court with the parents, the court may often not appoint a guardian ad litem because the court can judge for himself if they're going to need that.
And if they're not able to come to court, they're in the hospital, they're
Court
ill.
will appoint a guardian ad litem in all other cases.
And then, Greg, what will that guardian ad litem do?
That guardian ad litem is going to do what Nancy said, give the alleged disabled person notice of their rights, notice of the proceeding, and then report back to the court after taking in all the other information and giving the notice to the alleged disabled.
All right, thank you very much. We're going to take a short break now, and when we come back, we're going to talk about some situations and some further rights that an alleged disabled person has in court.
Bye-bye, Tyler.
Dear, it's time for serious talk.
Oh?
About my daycare. When I started out, it was just to help the neighbors. But lately, it's getting to be a real handful. I need some help.
What can I do?
I need advice on more space, a loan,
What about incorporating?
and insurance.
Wait, I know who we can call.
Times like this require sound advice. Your lawyer can help. A message from the Illinois State Bar Association.
It's your fault! Never! Never!
Over and over,
It's our problem! Leave me alone! Shut up! Out!
time and again,
No! Drive me nuts! Shut up! You're the dumbest
generation after generation.
I hate you! I hate you too!
Isn't it time we stop the cycle? Now.
I hate you! I hate you!
Stop adult violence. Teach kids peace. A message from the Illinois State Bar Association.
Welcome back, ladies and gentlemen, to this edition of Illinois Law. This evening I'm here with my guests, Nancy Spain, Greg Garofalo, and Meg Benson, and we've been discussing adult guardianships. We'd like to talk now about some typical examples of cases in which guardianship petitions are actually filed in court. Nancy, what's a typical guardianship case that you might bring to the court?
Well, very often if there's a case where a minor had an estate, maybe from a personal injury or an inheritance or whatever, if the child has a disability, when they turn 18, they are considered not disabled unless they're adjudicated disabled. So there must be a proceeding to determine whether or not the 18-year-old can handle the finances themselves. And if they can't, then the minor guardianship is the money, it stays in a guardianship when the person turns 18 because the child is determined to be disabled and unable to take that the finances into their own hands and handle them themselves at age 18.
In fact, give me an example of a situation where there was a lawsuit and maybe there was an injury during the course of birth, and now there was a child with cerebral palsy. Now they turn 18. Now they need to be adjudicated an adult because they still have severe disabilities. They're cognitively and physically impaired. And say they have an estate of $1.2 million. What happens then when you come to adult guardianship court under those circumstances?
Well, assuming there is a guardian of the minor's estate, the bank or whatever fiduciary might be the same, but there would be a petition, and generally the banks don't do the petitions. They want the parent to be the petitioner to appoint a guardian, and there's a guardian of the person. There would be a guardian of the estate. They may or may not be the same. There could be co-guardians of the estate. The parents could be co-guardians with the bank.
Is that pretty common that in that situation the parents continue, they were in their role as parents and now guardians of an adult?
Very generally they're guardian of the person, and oftentimes they're guardian of the estate because they want to have some say in what goes on, although all of it is determined by the court, so both the bank and the parents need to be involved in that decision.
Now, if you're able to bring that young person with you to court, and you know, many times they may have a special wheelchair, they may have a special tool to be able to speak to the court. Do you generally do that?
Yes, I think the judges like to see the wards periodically, at least very early on in the opening of the guardianship, to get a feel for what the ward is like, what their desires are, and what their needs might be.
Now, what will happen in a case like that once the alleged disabled person is adjudicated disabled? What further court proceedings will occur?
There generally are a lot when there's an estate, because the parents or the bank cannot spend any of the money without a court order. So generally there's a petition to establish a budget, and they need to present evidence as to why they need this budget, what would be the expenses, and why the ward would need these things. And of course the court is looking to see what is most appropriate for the ward. There also is annual accountings that are required. Anytime there would be a change, if there was a change in the residence of the ward, any of those things would require a court hearing.
Greg, what about you? What's a typical case you might file in the probate division?
Well, you know, a real common case is when I have children come to see me and say, Mom or Dad can't make decisions anymore. They're becoming forgetful. The doctors have recommended that maybe they come to seek a guardianship to make decisions because there's no powers of attorney in place. That's a very common situation. Another situation would be where there is an adult child who's always been taken care of by Mom and Dad because they've had some form of mental disability, and now Mom and Dad have passed away. And so now this adult child who still needs some care and some guidance and decisions to be made for them, maybe one of the siblings would step forward and file a petition so that they could make decisions for their sibling.
Now, what if Mom and Dad do have a house, the house was paid for, and mom and dad together might be living on Social Security and a small pension. How would the court try to deal with those expenses that they would be having on an ongoing basis?
Well, you know, it depends on what the disability. Let's take, for example, the dementia. It's always good to try to keep somebody who's suffering from dementia in familiar surroundings, and the court would always try to focus on maintaining the current status of the parents, so to try to keep them in their house if they could afford it. So as the guardian would have to come to the court and ask the court, present to the court a budget, and possibly if this house is paid for and it's their only asset, look at doing a reverse mortgage or something, or any kind of plan to try to maintain and keep them in the home. Because that's what the court's focus always is to make sure that what they do is in the best interest for the disabled person.
Are there any benefits that they might avail themselves of that they might not be aware of when they need caretakers in the home as opposed to going into a nursing home situation?
Yeah, there are some groups and some caregivers out there that they might be able to take advantage of. Caregivers in the home are very expensive, but there are several programs out there that they may be able to qualify through governmental agencies.
Now, what about you? What's a typical guardianship case for you?
Not to be flip, but their cases without the money. We do a lot of disabled children who are turning 18. Low-income families, they need to get guardianship. There's no money. They're probably getting SSI, which is a very minimal amount, about $300 or $400 a month to help support the child. But they need to get guardianship. We do a lot of those. We do the other end of the spectrum, a lot of cases where children are coming in and they need to get guardianship over an elderly parent who is either at home or maybe already in a nursing home. Again, the children have no money, they're low income, and the parent is living on Social Security. And everything in between when somebody needs a guardianship. Another thing that we haven't talked about but real briefly is when a guardian dies and you have to have another guardian step in, a successor. We see those cases. Again, a parent dies and a sibling steps in to take care, to become guardian over a disabled sibling. So all the same cases without the money.
And what about, I'd just like to touch on this, what about someone who's in a nursing home, their funds have been exhausted, can they remain in that nursing home, or what happens?
Once they're in the nursing home and they've run out of money and they're eligible for Medicaid, they can stay in the nursing home. The nursing home can't kick them out.
Now, we talked a little bit about a temporary guardianship, and I just want to touch on that because a lot of the temporary guardianships I see are when people are actually hospitalized. Greg, what are some of those situations that you see where you've been appointed as a guardian ad litem? Do you see a lot of those cases?
I do. Most often it's usually an elderly person who's admitted to the hospital and doesn't have anybody to make decisions for them. And so the hospital might petition the court for guardianship on a temporary basis so that medical decisions could be made for this individual.
Now, most of those people really are not able to come to court. So what do you ask them in particular regarding whether or not they want a guardian appointed on their behalf?
I'll ask them, do you think that you can make the decisions on your own? Do you think you need some assistance making the decisions? Would you welcome the help in making those decisions? And I would go through with what those decisions are, medical procedures, where you'll reside, what kind of medication you would take.
What if they object? What if they say they don't need anybody's help?
Well, that's their right.
And everybody's smiling because that's actually what we hear in court.
It is. That's their right. That's one of the rights they have, and I would come back to the court and I would advise the court that this person's objecting and that person's entitled to a trial and a hearing.
And is that person also entitled to have a lawyer to represent them at that hearing?
They're entitled to have a lawyer represent them. If they can't afford one, the court will appoint one to present evidence at that hearing to retain their own expert. The hearing could be by a jury of 6 people, and if the court decides that a guardian is appropriate, the court would consider what that person wants as far as who would be the guardian, but the court ultimately makes the decision.
Now, we've been talking about adult guardianships, but and Nancy did allude to it a little bit, but what's the difference between an adult guardianship, Meg, and a minor guardianship?
Actually, there's a big difference because minors are by definition disabled in one sense. A child who doesn't have parents who are there to take care of him or her, they need a guardian, because a child cannot make legal decisions for himself or herself up until the day they turn 18. On their 18th birthday, they are considered a legal adult. And those of us who've had 18-year-olds in the house are kind of horrified by that rule, but that's the law. So if a 17-year-old's parents die in a car crash, that child needs a guardian.
Who might step in a situation like that?
Again, it's going to be often another relative, a grandparent, an adult sibling, a friend's parent, someone like that. But the minute they turn 18, they're an adult. The difference is then they only need a guardianship if they're adjudicated disabled.
All right, and just briefly, because our program's coming to a close, can anybody who's once declared a disabled adult be restored and get their rights back? Nancy?
Yes, actually, I've been in a couple, and they're really quite, it's very wonderful to see someone, especially if it's a brain injury or something where they've gone through treatment and they've gone through rehabilitation, and then they are able to resume their life, yes. But there is a hearing, and doctor's reports are required. It's not easy, and it doesn't happen that often, but it can.
And you're right, that's very, very uplifting. We have to end our program now, but we thank you and we hope you've enjoyed both our programs on adult guardianship. It's been our pleasure to be with you this evening. Thank you for joining us.